This is the Rules Committee, 1 o'clock. At this time, Canaan, adado listo.
Dear Heavenly Father, we come before you and we thank you for this day, Lord. Thank you for these people and this nation that you blessed us with and let us be a part of. Lord, I ask that you would lead and guide us to make good decisions. Let us do what's best for our people, and let us give honor and glory to you in all that we do. And Lord, we just thank you and ask for your safety and ask all these things in Jesus' name. Amen.
Amen. Thank you, Canaan. Roll call, Shelley.
Joe Bird.
Ani.
Kanan Duncan.
Ani.
Keith Austin.
Here.
Harley Buzzard.
Here.
Julia Coates. Sean Crittenden.
Here.
Joe Deere.
Aye.
Mike Dobbins.
Here.
Rex Jordan.
Here.
Daryl Legg.
Here.
Wes Nofire. Dora Kutzkowski. Here. Mike Shambaugh.
Here.
Mary Bakershaw. E.O. Smith.
Here.
Janice Traylor. Here. Victoria Esquez. Well, you have a quorum.
Okay, you have a quorum. The minutes were mailed to you. At this time, I entertain a motion to approve. Okay, got a motion and a second. All in favor signify by saying aye. All opposed? Okay, dropping down the reports. Marshal Service, Mr. Shannon Buell, and I think he's with us.
Good afternoon.
See, oh,
Real quick, some of the stuff to highlight on this month's reports. Our Special Operations team arrested 2 armed robbery suspects. Our Special Operations team also have been assisting Oklahoma State Bureau of Investigations, looking for grave sites. The 2 female victims up around Pitcher, the murderers of those 2. One of those victims is Cherokee, or was Cherokee. We've gone up there several times over the past several years to help OSBI in digs and looking in the pits and stuff like that to see if we can't find locations. So we will always go up there and help them to try to find those little girls for their family. We've also did a high-risk drug warrant where we recovered 6 pounds of illegal marijuana, which is not the same as the medical marijuana. And we also had a special operations call-out in Tahlequah of an armed barricaded gunman. That's a suspect of a shooting in Tahlequah. So we resolved that peacefully, quite frankly, with some CS gas into the trailer, and he came out peacefully, and we put him in custody. Other than that, I am honored to look to my left. You have pretty much a legend of the Marshal Service and the history of the Marshal Service here today. L.D. Drywater, he's sitting over there in security. He spent a wonderful career here at the Marshal Service, and his dedication to the Marshal Service and now to security and to the tribe, I think, is unsurpassed by anybody else that I know. So thank you, L.D., for being here. Other than that, if there's any questions, I'm more than happy to try to answer them.
any questions for our marshal this time? Keep up the good work and stay safe.
Thank you.
Office of the Attorney General, Sarah Hill.
Pleasure to be here today. I'd like to remind all of you that L.D. Drywater did in fact work for the Attorney General's office for a small amount of time, so we should also get part of the love you have for him should be transferred also to my office. It's been a blockbuster month at the Office of the Attorney General, even by our incredibly high standards. We've had a lot going on. I can't possibly tell you about all of it, but I will try to hit the high points, and even at that, it may take a minute. I'll start with the approval of the 1999 Constitution, which happened, although federal approval of the 1999 Constitution was not necessary per our Cherokee Nation Supreme Court and the decision they made in 2006. I am nonetheless glad to report that the United States' first Native American Secretary of the Interior, Deb Haaland, did approve the Cherokee Nation's Constitution on May 12th. And although that doesn't have any real legal incidence to me or to the nation, based on what our Supreme Court had previously found, it still, I think, is an important sign of government-to-government respect that they acknowledge our Constitution. So I'm pleased to report it, although it's not really legally necessary under our law. The second, that would be the biggest issue on almost any report, but I don't know that that's the biggest issue on this report. The second issue I wanted to bring to your attention was an election issue. The Cherokee Nation filed criminal charges, 1 count of election fraud and 1 count of false personation against an individual who was falsifying absentee ballot request forms. And so I know that during the election law change discussion, the tribal council made it very clear to me that it was your expectation that people who committed crimes would be prosecuted for those crimes. And I wanted you to know that the AG's office is doing that. We've done some other investigations, but at this point, this is the only criminal charge that the nation's filed. And it will it will handle it like we would any other criminal case. An update on tribal court cases and processes, which is something that, I wanted to give all of you an idea of how the nation's AG's office is changing in response to the decision in McGirt. During my last report, I told you that we'd filed 660 new cases. Today, we are rapidly approaching 1,000. I expect we'll probably hit that next week. We've also received 129 referrals for juvenile offenses, which is up from 67, which I reported at the previous council meeting. So we continue to see a lot of growth in our case numbers. We've been moving forward to push out the draft memorandum of understanding that the tribal council authorized very recently to municipalities to help keep funding inside the municipalities. And we're working on pushing that draft MOA out to some of the municipalities that we've been talking to. Our office had a very good meeting with the Oklahoma Department of Public Safety. One of the challenges we've been dealing with is things like license points and license revocations in cases where people have been driving under the influence. And so there is no real process for the Department of Public Safety to accept tickets from tribal governments. But we had a very good conversation with the Department of Public Safety. They were very open to having that conversation with us, and seemed, they brought out some new legal counsel to represent them and assist them with their working with Indian tribes, which is encouraging. The different state agencies recognizing the importance of those relationships. We also had an extremely good discussion with Delaware County law enforcement, and really appreciate Councilman Shambaugh for sort of helping us facilitate that discussion. It's certainly in his area, both as a tribal council member and in his area of expertise. And although I was unfortunately not able to be there, my Sandy Crossan was there and Christy Nemo was there. And I think those are extremely good discussions. We bring up lots of questions we can answer. We bring up lots of questions nobody has the answers to, but we were able to put them on the list of things we need to work out. We're looking forward to having a very similar meeting with law enforcement in Adair County tomorrow. So we continue, and that's not the only. We've been throughout the reservation having these discussions, and sometimes they come down to Tahlequah and visit us. And we're going to continue to have those outreach meetings with law enforcement. I think they're very critical for us to continue to just communicate with one another, because there's no way that law enforcement is ever going to be a one agency job. We also had a ribbon cutting on May 11th in Muskogee on the new Juvenile Justice Center, which is adjacent to the Three Rivers Health Clinic. And that was a really important step for us. As you could see from the numbers on juvenile justice, this isn't something the nation really ever had very many juvenile cases prior to McGirt. And now we have already got over 100 referrals. And some of those are for things like truancy, and some of those are for very serious crimes. Assaults and batteries and, all kinds of criminal activity. So we're hoping having a juvenile facility, it will give us office space, which we need to house the Juvenile Justice Department, and a juvenile courtroom that's totally separate from the adult courtroom. So we'll be able to have juvenile court in a very confidential environment. Juvenile courts are different than adult courts in that we want juveniles to be rehabilitated, and we want, when they turn 18, to be able to walk away from that past entirely and begin their lives as adults with a totally clean slate, because they've had a chance to, when you're a younger person, you don't always have good judgment, or maybe you don't have good role models or good experiences in your life, and you're not as culpable for those actions as you are if you're an adult. And so we want to be able to help them to reach those goals. And we've been doing a lot of interviewing, hiring for also new people, new staff for the Juvenile Justice Division. So we're working on that. We're glad to have this new space, very, very proud of it. On May 11th, we had introduction of federal legislation by Congressman Cole, which would authorize compacting between the Chickasaw Nation and the Cherokee Nation and the state of Oklahoma. It would also contains provisions that provide for the territorial sovereignty to be protected for both of these tribes. I know that all of you have probably looked at that ad nauseum, and I've talked to all of you or most of you about that legislation. I certainly remain always available to discuss it and follow up with any questions that you may have, but I know certainly that's happened in the last month, and I can't not mention that we've had this other very large thing happen. And then just yesterday, as a sort of final aside, I wanted to update you on some other court cases that are going through the courts, and this is a much more important update today than I would have given you yesterday. There are a trio of cases in the Court of Criminal Appeals: Bossy, Cole, and Ryder. Bossy happened in the Chickasaw Nation, Cole happened in the Cherokee Nation, and Ryder happened in the Choctaw Nation. All three cases involve non-Indians who committed crimes against Indians. All three individuals are on death row in Oklahoma. The Court of Criminal Appeals overturned the convictions in all three of those cases, and they were refiled by the United States, but the state of Oklahoma requested a stay of the mandate. And that just basically means, although you've made your decision, court, we want you to hold off enforcing it because we think we might want to go to the U.S. Supreme Court and we want to ask for cert on these cases. They did that in Bossy. They requested a stay from the Oklahoma Court of Criminal Appeals, which granted them a short stay, and then they went to the United States Supreme Court to request a longer stay so that they could seek cert and keep these individuals on death row. The Chickasaw Nation, the defendant, and the United States Solicitor General all filed briefs in that case saying the stay should not be granted by the Supreme Court. And it talked about the state of the law, and I mean, the federal law, in my opinion, is pretty clear on that. Regardless, the United States yesterday did grant the stay. The United States Supreme Court granted the stay in Bossy. So that case has been stayed. If the court, and the state hasn't filed their cert petition yet, but if they do file the cert petition, and I'm sure they will, and if it's granted, then the stay will be continued until the case is decided. If it is not granted, if cert is not granted, then the stay will dissolve and the mandate will issue. But that was surprising that the Supreme Court would grant the request for stay to a lot of people, because especially when the United States went out of its way, and which was unusual for them to file a brief when it hadn't been requested. So that is concerning. The only three justices who dissented were Breyer, Sotomayor, and Kagan. So they're the only ones who said they would not have granted the stay. Cole is currently still, they have requested in the Cherokee Nation case, the Cole case, the state has requested that that the U.S. Supreme Court issue a stay in that case as well. I'm sure they'll do the same thing in Ryder. These three cases are very similarly situated. So that's I'll keep you advised about these cases as they move along, but they're much more concerning today than they were yesterday. We also received word that the Attorney General in Oklahoma is resigning as of June 1st. So we don't know what the cert petition will look like or who will be making those decisions right now. And the cert petitions haven't been filed in any of these cases. So that's just something I think that the council should definitely have on its radar moving forward. And I think that is the high points of May.
That's a long report, a lot going on.
Yes, sir.
So, any questions for our AG? Councilor Crittenden.
Yes, sir. Sarah, I have a state game warden that's not going to be there tomorrow or be able to. Do you have a list of the places you will be having those meetings that he may go or send? I know it's you've kind of left it up to different ones to invite the folks they want there, but if my fellow council people here, probably a good idea if the game warden was in on it, if you had a list of those kind of meetings.
We've actually had maybe the same member of a game warden reach out to us to have a discussion with us. So that probably merits maybe a separate meeting with the game wardens and with their staff. Just because they won't be the only ones. They'll be throughout the reservation, and the game wardens have kind of a specific responsibility, and some of their code provisions are a little bit different. So I think that's probably I would offer to set up a separate meeting to talk to the game wardens. I think that that's probably warranted in that case.
Thank you, ma'am.
Counselor Shaw?
Thank you. Sarah, with 1,000 mounting cases, would it not be in our best interest perhaps to hire district courts to assist us with these, to pay them to help us to prosecute them?
Those are conversations and discussions we've had. There's two barriers to doing that. First of all, no Oklahoma court can sit as a Cherokee Nation court. We just can't share authority that way unless we get the legislation like what we've talked about. We can't make a judge in a district court, a state court, a Cherokee judge, because judges in the Cherokee Nation have to be Cherokee, and they have to be appointed by the principal chief and confirmed by the council. And so those are a couple of the barriers that we've had in trying to find ways to get the district courts to hearing these cases. District courts do hear them, tribal district courts do, but there's no way to give the state district courts that kind of authority, and there's no way to let those state court judges wear the hats of tribal judges. Does that make sense?
Yes, but what if those judges were Native American?
They have to be, per Constitution, they have to be Cherokee.
They have to be Cherokee.
Yes, ma'am.
Okay, and I wanted to ask you about that Supreme Court yesterday on the McGirt. Would that not help us somehow?
I think the way that first of all, we don't know, organize my thoughts so I explain it properly. The state argued in front of the Court of Criminal Appeals that the case should not be dismissed because they have concurrent jurisdiction over non-Indians who commit crimes against Indians on the reservation. The argument that they made to do that had to do with the preemption power, and I think that that is not the correct legal argument, and there could be consequences, negative consequences, if the court bought that argument. Although I can see the value of that, and I think that their heart is in the right place in terms of wanting these criminals to stay in jail. But I think that the arguments that they're making are hazardous to the tribes in other ways. But that, right now, that's just the arguments they made to the Court of Criminal Appeals. I have no idea what arguments they will make on cert to the U.S. Supreme Court, because by then we'll have an entirely new Attorney General. So that sort of, to me, raises the level of uncertainty. I had a good idea of what the state was arguing, and I understood, although I don't agree with their reasoning, I understood why, and I felt like they were, like I said, their hearts were in the right place in terms of trying to keep these people on death row, these non-Indians who had murdered, Cherokee citizens, Chickasaw citizens. I just do not know what it will look like when it goes up on cert. I don't know what that cert application will look like under the new Attorney General, whoever that may be.
Also, I think that our tribes had a good relationship, pretty good, working with Mike Hunter, the Oklahoma AG, who's retiring June 1st. Do you have any clue who will be his successor and what the relationship to our tribe is?
I do not. He's resigning, and I understand under Oklahoma law, his successor will be appointed by Governor Stitt. So I have no insight into that.
Okay, I don't think I have any further questions at this time. Thank you.
Thank you, Councilwoman.
Anybody else? Good report.
Thank you.
Gwen Terrapin?
Good afternoon.
Good afternoon, Gwen.
You guys should have a copy of my report. We've got 12 FOIA requests. There are no GRA requests, and everything on the website's been updated also.
It's good to hear. Ever since you came on board, we've got caught. We're caught up now.
Yes.
That's good stuff. We used to be way behind now at one time. Yes, Councilor Buzzer.
Gwen, I had looked at your report and asked the CCO director about policies for CCO organizations.
Yes.
And I noticed in your report you had an extension on it for 10 days. Are you familiar with what's going on there? We don't have that policy, or?
Well, we have up to 30 business days.
Yeah, I understand that, but I guess they don't have a policy that they can't produce it to you. Is that the problem?
They are supposed to turn in the information to me by Friday,
Okay,
is when the information is due.
okay,
So I haven't heard anything from that department at this time,
okay.
so the information should be given to me in
Request
time
it.
to get
Okay.
everything together and give it to them.
Okay, well,
Yes, sir.
hopefully we get it out. All right.
Yes, sir, we
Thank
will.
you. Thank you, Gwen.
Uh-huh.
Thank you, sir.
Is that good? Okay. Anybody else for Gwen? Keep up the good work. Tell
Thank
your
you.
staff we appreciate them.
Thank you.
Tax Commission, Sharon Swepston. She always has good news for us.
Afternoon.
Good afternoon.
Can you hear me? I got this one. Okay. I believe you have my report. I'd just like to point out in that report that with motor vehicle, we have about a 14% increase in our revenue compared to this time last year, which was through March on your report. So that's good news. And little bit of bad news, not real bad. The J office, just in case anybody gets any phone calls, I've already made sure that Councilman Shambaugh is aware, but it is closed until June 1st due to some renovations being done in that building. And just for the safety of the staff and the customers and stuff, we went ahead and moved that staff to Catoosa until June 1st, but they'll be back open on June 1st. So it's just a few days, but we felt like it was important just to make sure everybody was safe.
See, even your bad news is good news. Yes, Counselor Buzzard.
Sharon, doesn't, who owns the building? Is it the Housing Authority?
Yes, sir.
Okay, so, but what happened up there? They just put a new roof on it.
Well, I think they had some storm damage to it. And then when they got in there doing the renovations to fix it, I think they found some asbestos and they're trying to clean that out and everything. So they're getting all that taken care of.
Well, we just need a new tag office up there is what we need. That building is 50 years old.
I know it's very
I
old.
can imagine there's more asbestos in there than what they found.
Well, and this is on the career services side. You know, the tag office part was built on.
Yeah, yeah.
So that was built on, but they're trying to get all that cleaned up there, so.
All right, thank you.
Uh-huh.
Anybody else? Yes, Counselor Shaw.
Hi, Sharon.
Hi.
Sharon, I don't know if this has been asked before, but I'll repeat it. Are we issuing real IDs?
No, we do not.
Is there a reason?
We've not ever done driver's license or anything. That would be another agreement that we would have to get with the state if we were to do something like that. But we've just not ever done that.
Do you feel, as department head, that we should be issuing them and have the ability to do driver's license testing?
You know, I really haven't given it a lot of thought to do that, but it would take a lot of additional staff and machinery and different things to do that. So it would be a big undertaking.
Okay, well done.
Anybody else? Yes, Counselor Shambaugh.
Hey Sharon, I stepped out of the room, I apologize, but thank you for letting everybody know what was going on at the J Clinic. They all took it very well, and they were very appreciative of the communication that you guys did, and giving them, you know, hopefully a firm timeline when it will be opened back up, but
Yeah.
they understand, and they were appreciative of you for letting them know that. I just want to say thank you.
You're welcome.
Well, you said June the 1st, right?
Right. So
That's
it'll be
next
back
week.
open on Tuesday.
That's pretty quick.
So,
Okay. Yes, Counselor Buzzard.
Sharon, on our veterans, I noticed our numbers have come up in the last 6 months or so, but do we actively engage the veterans to get those tax exempt cards?
we have made the information available, especially to our Veterans Center over here,
Okay.
and work with
And
them.
that's what my question.
Yeah.
Okay. So I wonder, well, I guess I need to ask the Veterans Center, do they have a list of all veterans that are Cherokee?
Yeah, I have no idea.
Okay. All right, I'll find out.
Okay,
Thank you. Thank you, sir.
Okay, good report, Sharon.
thank you.
Next, we have Gaming Commission, Janice Purcell. And I think she's here. It's good to see these people in person, finally. be able to look at them.
Thank you. Good afternoon. I submitted my report, and what's been going on since then is we posted our agenda for the next meeting. It's June 4th at the Chota Center. We're also doing it as a blended in that it's also a WebEx meeting because there's limited capacity at the Chota Center, so we want anyone that wants to be involved in the meeting to be able to access it. And that's posted at cherokee.org. We've also been inspecting the Catoosa Smoke Shop, which has games in it, and it will reopen. So we have to send a reopening letter to NIGC. We've also been working on, we being CNGC, on some standard operating procedures because there's been so many changes to gaming that we have to keep up with that. And we're also 90% vaccinated at CNGC.
That's good. You're doing a good job. That may be the highest in any department. Anybody else? Okay, good report, Janice.
Thank you.
Human Resources, Alana Castile. And I think she's here.
Good afternoon.
Afternoon.
You all have my report. If you have any questions, I'll be glad to try to answer them for you.
Yes, Counselor Deere?
Just a quick question. Before with HR, it was taking a while with getting responses back to people that applied for jobs. Has that pace picked up a little bit?
Yes, we have implemented a, where we can text applicants instead of relying on email or regular mail, and that seems to be working a lot better.
So when they get their first email, it's we received your application, and do you tell them what the process is and where it is and decision-making?
I'm not sure exactly what that communication is, but I can check.
Because the problem before was people were in the system waiting, and then they would see somebody got hired in that position, and they would not reach out and tell them.
Right. With the communication, with the texting, they're getting more communication.
Okay.
It seems like people use their phones a lot more than getting on emails. So it seems to be working. We haven't had any complaints yet.
Okay, appreciate it. Thank you.
Uh-huh.
Anybody else for our Alana? Okay, good report.
Okay, can I just say
Sure.
one thing? In case you guys hear anything about employees possibly being fired if they don't get the vaccine, that is not true. They will not be fired.
You know, we tried to clarify that the other day. That's been a really point of discussion, some confusion in certain areas there, that if they did not get vaccinated, it would be terminated. And I think the executive order, I had our PR lady to clarify some of that on our website, and I hope that did take care of some of the questions that are out there.
I hope so too. That would keep me really busy.
Yes, I know. It was really, I received several questions on that, and so maybe that will clarify some of that.
Yes, yes. And if they ask you, please tell them they will not be terminated for not being vaccinated.
Okay. Counselor Legg, you all right with that?
Want to make sure that we didn't make anything punitive for new hires
Sure.
and some of our participants. You know, just incentivize all we want to, but never make anything punitive because I never want to be a barrier to anybody getting a job.
Okay, anybody else on that topic? Okay, thank you, Alana. Thank you for clarifying that. Okay, old business, none pending. Drop down to new business. Counselor Nofar, you want to take that first one?
This is a resolution expressing agreeing to choice of law and binding arbitration and authorizing a limited waiver of sovereign immunity of the Cherokee Nation in connection with the use of Rank 1 Sports website. And I put that in a form of a motion for its approval.
A motion and a second. Any discussion? Yes, Counselor Dobbins.
Is this something that we're having to do as Sequoia High School to comply with OSSAA regulations? What exactly is this? What are we agreeing to do here?
This is an ongoing agreement that we've had, and, that's been questioned several times about the waiving of sovereign immunity, and the agreement is only, what is it like? Is it like 2,500? 25,000? What is that, Tara Lee? Do you remember?
It's a small number, Speaker. I don't have the exact number in front of me, but we renew it every year. It has to do with our reporting of concussions and sports-related.
Yeah. And I'm not sure if, is that with OSSAA? Okay,
That's what I was going to point out. It's required by OSSA.
okay. Are you okay, Counselor?
Yep, good. Yep, thank you.
Okay, all right. Okay, we got a motion and a second. All in favor signify by saying aye. All opposed? Okay. Counselor Vasquez, you want to take the next one?
Yes, this is an act amending Title 12 of the Cherokee Nation Code annotated, establishing the Anti-Harassment Act of 2021 and declaring an emergency. Put that in the form of a motion.
You got a motion and a second. Any discussion? Yes, Counselor No Fire.
I've been looking over this Anti-Harassment Act of 2021 is what it's called. And as I'm looking through here, I see a real question of a threat on our First Amendment rights, which is freedom of speech. And so, they're actually in Part 2 in Section 1502 under definitions, unlawful harassment. It says, if you go down through here, it says a specific person which seriously alarms, annoys, harasses, or is detrimental to such a person, which serves no legitimate or lawful purpose. And the other thing is that I've noticed looking through this is in most criminal codes that we have, including the state, it shows that one must be have a criminal action against it. So no longer are you threatened. You're threatened with the force that causes a crime. So a police officer is going to, write you a citation that you made a threat with a firearm or a threat that caused a criminal action to happen. So therefore, you can go get a civil protection to do that. The other course of action is that one must have a previous relationship. So spouse, boyfriend, girlfriend. So there's something that there to it. With this states is what it looks like as though if someone says something that you don't like, annoys you, harasses you, in a sense that could even be social media, then you could go take a civil act against that person just for freedom of speech for what they're saying that they don't like. And as council members, I think we all took a job to where we knew we were going to get attacked for things. I've been attacked for things. I think we all have been here and been addressed by constituents and otherwise they didn't like what we did. But that doesn't give us the right to go file a civil protective order against them. So I think there's some issues with this not mirroring what states have done in the past, which is making sure that those two things, one of the two have to be required. So I see Attorney General Hill over there. Maybe she wants to clarify how this doesn't conflict with the First Amendment right of freedom of speech.
Yes, let's have, Counselor Duncan, you got something to add to that before?
Yeah, I just wanted to point out, if you go back on Section 1 there, it says, but does not include constitutionally protected free speech.
Yeah, I see that it states that there, but it doesn't stop someone from trying to use what they feel as a reason to go to file a protective order. And of course, there's up to 14-day waiting period in which a police officer or marshal could come in there and start seizing your weapons because that's the natural causes that happens after someone's been filed a protective order against while you're waiting your trial.
I would say, council members, as long as you're performing your duties as a council member, then I don't think this applies to you. Yes, Councilor Shambaugh.
But also, I think with anything that you can read into anything you want to say and say, what if? But it's actually what it says in there. It puts out the parameters of what, I know it says that, but what if? No, there is no what if. Those are the parameters of what you have to violate to be charged with it. I mean, there is no thing outside that. That's the difference.
Well, it doesn't follow what we've always done throughout history with a lot of our different states, which is stating that you have to do one of the two things. And I'm not an attorney, That's why I was asking Attorney General Hill, and I actually asked our legal, who didn't even have this copy. So whenever I sent it to him, there started to be some questions about it, and then you have what the process, it's due process that I think it violates on related to seizures of fire alarm, which is also a violation of Second Amendments. I think this is a real issue, bringing it forward like it's been brought. I think that, anti-harassment is a very important thing that we need to address, but we also don't need to make the written law that we're passing start to infringe on constitutional right, even though at the beginning of it, it may say such a thing, but when you start getting into the law, it's explicit that, as elected officials, we're going to get some backlash on things, and I think it could be used to start putting, that in place where someone could file civil suits against somebody else.
Sure. Let's hear what our AG has to say about that.
I think that Councilman Duncan and Councilman Shambaugh both said, more or less what I would have said, which is that it's very clear that constitutionally protected free speech, it cannot be considered part of a course of conduct. And I think, that's explicitly clear in the legislation. There are certainly circumstances, and there's, this is not the first time that this kind of language has appeared in Cherokee Nation law. There's already civil protective order language which covers much of this, including the ability of the court to remove firearms from your possession if you are subject to a civil protective order. We know that if someone is a victim of domestic violence and there's a gun in the home, she's more likely to be killed by her partner than if there's not a gun in the home. And so the court can do that. Under our current existing civil protective order, the court has the authority to do that. And if the council will indulge an example, I think that's kind of helpful here. I think a circumstance where you would have, under the previous law, the civil protective order, if you don't have a pre-existing relationship to that person, you have no access to the courts. And so you take someone, just as a fictional example, someone like the deputy chief, and he looks like he could, in a fair fight, probably hold his own. But also, he's a public figure, and there are people that have strong feelings about him, about the positions he's taken. They feel like he owes them something. And there could be someone in the community who might say, I hate you, Deputy Chief, and I think you should resign, and you're awful for Cherokee Nation. And people can say that all day long about any one of you who wants to. That's freedom of speech. But if that person mails a spent shell to him and says that he's a danger to the Cherokee Nation and someone ought to take care of him, and someone starts coming to restaurants that he's at and leaving spent shells on his table and walking away, and then that person puts out on Facebook an ad that has a time and date where he's going to be and a target on that, and they say you should come and see what happens at this event here at Cherokee Nation, then I think you have someone who needs to go to court and has a actual credible threat of violence that he can, and maybe the court hears that and decides, hey, I don't think this is a credible threat of violence, but I believe that even though this person is essentially a stranger to him, he would have both a need for and a right to go to court and say, I would like a civil protective order. And I think it's reasonable for the court to issue an order saying the weapons need to be removed from that person. That person has made what I consider to be a credible threat of violence. It wouldn't be up to me. It would be up to the court to decide, but that's what we trust them to do. We trust the courts to know the law and to apply it fairly and not to violate people's constitutional rights. And I think that this legislation fairly provides an opportunity for people to seek protection when they need it, and provides protections for individuals. It's very limited. It can't go beyond 14 days if it's issued ex parte. It can't go beyond a year without being renewed by the individual, going back to the court and showing that there's been a credible threat. And so I think it strikes a nice balance of protecting the rights of individuals and also giving people, and in this day and age that we live in, sometimes the people that threaten you are not people that you know. And sometimes people, they decide for whatever reason they just don't like the look of you, or they don't like something that you said at a meeting. And this is not to protect members of the council or to protect members of the administration. This is to protect members of the public who may find themselves in this situation and need of protection. And also, this is not the only law like this in the country. There are many states that have adopted similar anti-harassment laws.
Thanks for the breakdown of that. In the definitions, and especially under the protective order petition under 1504, it states that a person who has suffered harassment is defined in section 1502, unlawful harassment. So, because we could use examples all day long. I've got two of them in mind to where it could be used not correctly. It would violate someone's freedom of speech. I've been attacked being a racist by someone out of the administration's office on social media. But that could annoy me, or it's alarming that I've been criticized that way. But I don't have the right to go file a civil protective order against that individual, and I don't think I should, because that's their choice of how they feel about the position I took. I don't agree with it, but that's just the position they took on it. Now, another example would be as if my wife was getting hit on by a guy, and I told him I was gonna, physically hurt him if he didn't leave her alone. Does him then, because I annoyed him or harassed him by telling him that, allow him to go get a protective order against me when I'm trying to just simply put a statement that I'm trying to protect my wife? So it could be a very double-edged sword whenever you leave things like that out there for interpretation, whenever it's just people who have conflicts against one another trying to either protect themselves or trying to just say they disagree with someone's stance. And that's where the freedom of speech gets violated. And that's why it needs to just stay in tune with what we've done through the state, which is saying, credible threat of violence has to be shown with either a criminal or a relationship intent. And so that's just the way I think a lot of people that I've spoke out to, attorneys, people, my constituents, feel about this law.
I would only comment, Speaker, with your indulgence, that people can file whatever they want to in court. I mean, that's why we have judges, and that's why we have to be careful about the laws that we pass. But nothing in here, he's right, nothing in here would prohibit me from going and filing an action against every single person that ever said something bad about me on Facebook. But nothing prohibited me from doing that in the first place as a civil protective order. We depend upon the courts to apply the law and to do so fairly and consistently with the Constitution. They're our defense.
Okay, Counselor Shambaugh, you have something to add?
Just really quick. That's basically what I was going to say. Anybody can attempt to file anything against anybody, but that doesn't mean it's going to happen, because the judge will make a ruling whether or not it falls under that category of law or not. But that happens all the time. Also, I had to work with the Homeland Security once because we had a hate group coming to, well, what was considered a hate group coming to protest an event in Jay. And what Homeland Security said to me, he said, what do you know about the First Amendment and the freedom of speech? So I don't care what they say, as long as they don't threaten somebody. They can pretty much say whatever they want to say, and we can't stop them from saying that. And Homeland Security said, well, as long as you stay under that guideline, then you will be fine. And anybody who's ever done this for a living, a judge, an attorney, that's the way it is. I've been in court 100 times on protective orders, and when I was a bailiff, probably more. I saw them every day, and I was sitting in the judge's office. So anybody can bring anything, but if it does not fit the criteria, you will not get a protective order. And to get your guns taken away from protective order in the state happens all the time, absolutely all the time. It's not just something that now there is a review, there's a period where it gets reviewed to see how the case is going. If things are going back, well, then the judge can say, hey, you know what, we're going to lift this, you can have your guns, you can hunt, because that's a big deal, when people can't go hunting and things. But I've seen a lot of that, and it's just because it said that, that's up to the judge to determine the severity of the case and the circumstance, whether or not those guns need to stay or go and how long. That's the way it is in any court.
Anybody else? Counselor Shaw.
Attorney General Hill, can you please tell me if this legal information when we receive it, that our tribal council attorney receives it too?
I presume that he gets the same books that I get, but I don't know for that for sure. He could answer that question better than I could.
Could you please see in the future that he receives it?
Yes, ma'am.
Since he represents us? Thank you.
Certainly.
Yes, no fire.
Has our, Tim, have you been able to have a chance to read over this?
Very quickly.
What's your first indication on it, just as face value, what you see?
The standards are going to be unconstitutional, the preponderance of evidence versus beyond reasonable doubt. You already have a criminal statute that defines that, harassment has to be proved beyond reasonable doubt. like 90% proven versus a preponderance of evidence is anything over 50%. So if the judge thinks, this probably happened, then he can take her down. I think that's why it's going to violate the Second Amendment.
Appreciate it. Thank you. And since that advice from our legal that it could be doing those things is something that I have an issue with, and I won't be voting for this bill. Appreciate it.
Councilor Vasquez, did you have a question?
Nope.
Okay. Any other questions before we move on? We have a motion and a second on the floor. Is that correct, Shelley? All in favor signify by saying aye.
Aye.
All opposed?
Aye.
Okay. Okay, item number 3, Councilor Legg, you want to take that?
This is an act amending Title 21 of the Cherokee Nation Code, annotated and declared an emergency. I put that forward motion.
Got a motion and a second. Any discussion? All in favor signify by saying aye.
Aye.
All opposed? The ayes have it. Number 4, EO, will you take that?
Yes. It's an act amending Title 22, the Cherokee Nation Code, annotated and declaring an emergency. I put that in form of a motion.
Got a motion and a second. Any discussion? All in favor signify by saying aye.
Aye.
All opposed? The ayes have it. Councilor Shambaugh, you want to take the next one?
Number 5?
Yes.
This is an act amending Title 47 of the Cherokee Nation Code, annotated and declaring an emergency, and I put that in form of a motion.
Got a motion and a second. Any discussion? All in favor signify by saying aye.
Aye.
All opposed? The ayes have it. Councilor Taylor, you want to take number 6?
Sure. This is a legislative act amending Title 62 of the Cherokee Nation Code, annotated public finance, and declaring an emergency. I put that in the form of a motion.
Motion? Second?
Let it be on the record, it's a revised version that we were handed out today.
Does everybody have the revised version, number 6? Okay. All right. Any more discussion? If not, yes, Councilor No Fire.
Just want to make sure, because that revised version I hadn't looked through, so I just wanted to give it just a quick glance over.
Councilor Taylor, would you explain the revision?
Well, I think it was fairly minor, I went over this.
Would Councilor, not Councilor, but would you get our CPA in here, please?
Trey, okay. I was gonna say, I think the change had to do with the investment committee.
The Investment Oversight Committee.
Yes, and,
Okay, we have our treasurer here. Trey, you want to cover that?
I do. This was actually a change that I had requested. It's on the last page in C, under the Investment Oversight Committee.
We're covering resolution number 6, Jody. Legislative Act. Councilor No Fire had a question on what the amended version was.
Okay, Trey's gonna go over them.
What was the question?
What is the amended version? Well, there's a substitution for Legislative Act number 6, item number 6. So what's the amended version? What are we changing here?
She's got it. She said she's going to cover it.
Yeah.
I've been looking more at the new budget stuff than this particular item, so.
I believe you guys will recognize Mr. Cloud. He is my investment advisor. So Just a few minor changes on this after we had conversations earlier in the week. Under section 23, if you look on page 5, that is a small technical change. The very last sentence under section 23A, where it said 62 CNCA, it did say 23F. That should have said 20F. That was a scrivener's error, so that has been corrected. Under section 24, we removed 24A, and then under little I3, that section A, upon further consideration, we determined that was best left to the investment policy statement that is referred to further on in the statute, so we took that section out. It was a small section that just spoke about anything that was less than 6 months, keeping it in certain asset classes versus things that, would mature after 6 months. And the next three are almost the same. So it's under section 24A4. In the first sentence, we included the phrase, but are not limited to, after include. So it now reads, types of financial instruments allowed for short-term investments include, but are not limited to, interest-bearing bank deposits such as certificates, et cetera, et cetera, et cetera. The reason we added that is because over time, new types of investment instruments become available, and we didn't want to lock us into just what's listed here. And that is something that, what we can and can't go into would be more well-defined in the investment policy statement. But we didn't want to exclude ourselves from maybe getting into a good new investment instrument because of limiting language here. That same change was made under section B, section 5. Again, investments include but are not limited to. And then the same change under C, little I 3, investments, and then we took out the word within and changed that to including but not limited to, both equity and fixed income, et cetera. There was another scrivener's error in 25B. About midway through that paragraph, it says the treasurer or his or her designee shall consider the long-term and short-term needs of the Cherokee Nation. We just inserted intermediate term there to coincide with the three levels of investment pools. We have the short-term, intermediate term, and long-term. That was a scrivener's error, that intermediate term was left out. The major change here, and the one that was most brought up on discussions prior, is this Oversight Committee, which is section 25C. And after taking the council's suggestions into consideration, what we have proposed is to remove the treasurer from the Oversight Committee, because in retrospect, it doesn't make a whole lot of sense to have the treasurer overseeing the treasurer. So we removed the treasurer, and now the Oversight Committee will be made up of the controller and the Executive Director of Financial Oversight, which is actually the Tribal Council's CPA. That would be Jody Reese's title.
Okay.
And then 3, we left the Attorney General or a representative from the Attorney General's office. And then in that very next sentence, we removed, obviously, since the treasurer is no longer on the Investment Oversight Committee, the treasurer can't be the chairperson, so it now says the controller shall be the chairperson of the Oversight Committee. And then the final change that was made is still under section C right there in section 25C, little I2. We changed the word recommend in that sentence from recommend a reporting schedule, and now it says establish a reporting schedule to the tribal council. So that is a summary of the changes. I think the only one of substance, the major substance is the Oversight Committee. Of minor substance is that instead of recommending a reporting schedule, is establishing a reporting schedule. So happy to entertain any questions that we might have on that. Like I said, Mr. Randy Cloud is here.
Counselor Shaw.
Yes, since we have your investment advisor here, could he please tell us what the average return on our investments last year did? What average percentage?
I'm sorry?
Could you please share with council what the average investments did? What was the rate of return we had on our investments last year?
I don't actually have that. I know that you were invested completely in CDs, very short-term treasuries, all of which have had declining interest returns. And I think we were in single digits for.
We've been in single digits for quite a while.
You know, when we say single digits, let me clarify. Forgive me for the industry speak, but it's important that that we can communicate on these topics. A dollar is 1%, or a penny is 1% of a dollar. The industry uses a term called basis point, which a lot of people confuse with percent. A basis point is like you took the penny and split it 100 times. So 1/100th of 1% is 1 basis point. So current short-term treasury yields are so low that they are at 1.5 basis point per year. And with the bank's transaction charges, there's nothing left. So things have ground down that much. And this is a trend that has been coming on for a few years, but that was just hammered by the pandemic. So I know that as COVID relief money came in and everything else, the Cherokee Nation's assets had this huge bulge, but their limits on how much they could put in CDs and things with the various program sponsors through the banks, they said, you can't give us any more money for those. And all they could do then was buy the short-term treasuries, which is what you have always had, and have not deviated from that. The only change here recently with $1.8 billion, we did implement utilization of some money market funds that also invest in treasuries, but they go out to 4 months. So they get a little bit more. We're in the three plus basis point range on those, where we were down at 1 basis point. And may I go on to the risk while I'm talking about this? Is it healthy? Just go ahead and.
Yeah, there was one more aspect that we wanted to speak to on this, just to make sure that council is fully aware. So I will pass this out while he speaks to it.
I've done this for 35 years, and I've served multinational publicly traded companies, and I can say that the number one thing is transparency and very good communication with the governing body. Whether it's a 401k investment committee, a board of directors, or a group like yours. And when I was hired and I began reviewing your existing legislation and existing policy, I first go try to connect the dots on the changes that have happened ever, but certainly recently. And when I read the last revision to your statutes, there was a change from having assets solely committed to CD deposits and short-term treasuries, which they had always been in. And the legislation most recently passed opened that up using the term investment grade, and also going to 5-year terms. And that doesn't sound like a big deal. You've been in bank things, investment grade, those are probably the same. They're actually very, very, very different. And as I was trying to reconcile your existing legislation and communications regarding it, I wasn't compelled that the discussion had been had in full enough detail to warrant Treasurer and Investment Committee taking on any risk with tribal assets. That's something that needs to be specifically blessed and understood, or not. If it's forbidden, then we need to change a lot of things here, including what's already been passed. Because as I stated, the most recent act before this one already approved 5-year terms and investment grade. Investment grade can be foreign governments, it's corporate debt, and it's anything down to a BBB rating. So for the purpose of illustration, this picture is worth hopefully 1,000 of my words. The dark blue line, the very smooth dark blue line at the bottom, that's what you've always had. That's what you still have right now. It has not been deviated from. You're invested completely in insured and U.S. government-backed guaranteed debt. It is the safest haven on the planet. So any departure from that, as your stewards and fiduciaries, we need to make sure is well understood and that everyone's on the same page as far as going forward. So the other lines here, there are many, many classes of bonds that are covered when you open it up to 5 years and BBB. There are a whole lot of them. But just for the sake of illustration, I included 3 of them. And they serve to represent, in this picture, the fact that they're higher return, that's not the point. The picture is they go up and down, where what you've had before never went down, ever. Didn't go up as much, for sure, but it couldn't go down. And so we wanted to be sure that, number one, council was well advised and informed on the intention to move forward with the assumption of some small measure of risk. The stock market's not on here. It'd be off the page if the stock market was on this chart. But we needed to open this discussion and make sure that we were all together and understanding with respect to whether risk would be taken with tribal assets, or if it would be only taken, for example, with long-term assets in the sovereign wealth fund, but not in any other manner, et cetera. And if it was okay, in fact, to, for example, go for the green line, have a little bit of return, but a little bit of risk, we need to state that, which is what is in this document, and establishing a very significant set of safety bumpers that says you can only go this far with money that's going to need to be spent within 18 months. And to tier it from 6 months, 18 months, 3 years, et cetera. So nobody gets up in the morning trying to do a bad job, but it was apparent to me that we didn't have probably enough detail in what had gone before to make sure that we were doing your will perfectly. And so that's behind these rather lengthy descriptions of short, intermediate, and long, and we wanted to have a healthy, constructive discussion to make sure we were going the direction that is the one you intended when you passed the last act.
Good words. Thank you for that explanation. Anybody have any questions to that? Yes, Counselor No Fire.
Yeah, I had a question, well, more of a suggestion, just because it's kind of, we tried to clean up, like you suggested, the last act that we passed, which I think was a lot of work from the council. Some of them, I think, are still here when the last Sovereign Wealth Fund Act passed. The biggest concerns to me, and I think that I may make it friendly on it, is to strike the not limited to, because the council does not have aware of where it would be invested in all. It'd be kind of a more free-for-all on investments, whereas, before, we had it limited to what we're investing on, and if there was any such changes of what future investments this new advisory investment oversight committee would like to bring back to the council, or every month the E&F, the treasurer here, she comes back to make suggestions on the next investment step that we would like to take, but not knowing exactly what we would be limiting our investments could be something of a concern to where we'd be putting a bunch of money and a bulk of money. We don't know if we're investing in the Republic of China or where it's going whenever it's not limited to something.
If I could add some thoughts along with yours for consideration.
Sure.
One of my responsibilities earlier in my career was helping draft policy for fiduciaries at one of the credentialing bodies. One of the things that we intended to, or that we did build into the protocols, was the spirit that investment policy, to be successful, is a breathing document that lives and evolves as the landscape changes. So on the one hand, there's absolutely nothing wrong with putting boundaries, which we feel that we do have boundaries in here. But there's nothing wrong with saying, okay, we're going to draw them closer or farther, and then revisit them when and if the time comes that we need to. I think that when you, and this is where we go from being lay people to investment professionals, including but not limited to both equity and fixed income securities. I can't honestly tell you right now what that would be. I can't imagine what it is. But 30 years ago, I couldn't imagine exchange-traded funds and things like this. So, I can support either approach to say, they could be dialed in, and the committee can come back to you and say, hey, we need to add a new vehicle. I will tell you that right now, the capital markets are strained from the huge influx of cash. Just like your $1.8 billion, there are a lot of other similar things. Everybody's hunting the same Easter egg of where do we put the money? And, all the limits are stuffed full, and we haven't actually seen a new product class yet from the industry, but I imagine that we will in some form. But I serve you, it's what you as a governing body want. How much fence do you want to put around this? And remember, I started with, is it even okay to get out of the blue line and go anywhere else? We think it is because you passed that previously, but we wanted to make sure that you understood and have it defined before we take action and go forward with any of that. So does that help?
Absolutely, and I really appreciate the detail, and in fact, that, to me, and I may refer to Council Taylor here since she's our chairwoman on E&F, I love the idea of approach of saying it's limited to, and then having you on with the treasurer there whenever you see an idea coming up, to coming back and saying, hey, let's make this right here, let's invest in this, because this is what we see is gonna be happening, instead of just kind of leaving it blanket. I wouldn't expect you to go buy Bitcoin or anything right now at the money, but I do see that maybe a limited two is a good place. We've already kind of started there, but keeping it the same until we see what's the next approach. What is that Easter egg? You know, I don't think if we ended the ENF today and then tomorrow we found the Easter egg, I don't think that the Easter egg would be hatched, so to speak, if that's the terminology we were using, by the next ENF in just 30 days. I think in 30 days, we'd be able to make that change and then get into that investment right then and there. So that's just my suggestion, and I had mentioned Counselor Taylor, so I don't know if you have any comments on those suggestions of possibly just limiting to that, and then maybe growing it from there with their advice.
Go ahead, Counselor Taylor.
So, you get in early, I mean, it's always better to get in a market early than to get in a market late. And one of the things that was a concession on this was the Oversight Committee, okay? My thinking on the change in that was that by having council's CPA on that Oversight Committee, whoever that is would have an eye on that. It would be essentially the same as council having a say in those investments. So that's kind of my thinking on that. But not limited to is not a big deal to me, but I hate for us to miss out on something when we've got our own CPA sitting in that room when those decisions are made. We're covered, but it's not the hill I want to die on.
I understand that.
If our CPA wasn't involved, I would have questions about that, but he's our eyes and ears, and he's been.
And yes, going forward, we will always have a representative in that.
Right.
So that's my thinking.
Okay. Does that, I like the explanation myself.
Yeah, I do too, and I'm glad we've had this conversation and been able to kind of understand it a little more. I'm not a big investor myself, and so it's just diving into it and having people here to be able to discuss those things is
The visual
pretty
is
good.
self-explanatory. We've just been going at a kind of a similar
Right,
pace here.
right,
and
right.
we're going a little bit higher than that now.
Yeah, I ain't got that
Yeah.
kind of money to be investing, so it's good that we have
Right.
these conversations before we make changes.
Trey, you want to wrap it up?
Yeah, I just wanted to kind of build on what Counselor Taylor said, was that there's also going to be that investment policy that the Oversight Committee is going to be responsible for putting together. And that's absolutely somewhere where we can limit what we're in. And then if we want to ever expand, if there is a new investment instrument that comes available, that's the document that I see as being more nimble and quickly adjusted rather than amending a whole statute every time. And that would be where, the council CPA would be on that investment oversight committee that would have the input on adjustments to the investment policy statement that we would have to follow on those things.
And if I could add, just to be clear.
Sure, go ahead.
There's nothing that I can imagine us doing right now that's anything but very boring. Because.
I will say that I'm very conservative with the money, so there's nothing that I'm gonna jump out there and do, for sure.
I don't envy your jobs, having to figure out the wise thing to do with all this money in a short period of time. Because I've told Treasurer earlier today, it's like an 80s movie or something. Here's this giant amount of money, you've never dealt with that much at once before, and by golly, it's gotta get spent in this period of time. And a lot of it runs absolutely counter to our little voice, our prudent steward voice of we need to be methodical and precise and deeply consider everything that we do. I want to encourage you also that as a team, your organization has made 1,000 decisions right. Sadly, those fade. The mistakes are the ones that remain easy to see after the fact. It is impractical and impossible to presume that this will be executed without mistakes or perfectly. But we're trying very diligently. And for example, is it okay to get away from the blue line? You know, that was question number one. If so, here's how we're going to define it. And the investment policy that we kind of had in the document in the first draft, we said, you know, that's the kind of thing that's going to need to change. Not necessarily a lot, but it will need to change. That should probably remain investment policy that is managed by the Oversight Committee. So I don't want you to have the impression that we're going to be doing day trading or anything other than, you know, taking money to Vanguard and saying, you know, let their guys put it in the most conservative bond portfolios that they have. You know, very, very conservative things. The one caveat is there is value to having those decisions reported after the fact rather than before the purchase, so that no one in the marketplace can front-run your trades. Front-running is taking advantage of where they know your money's going, okay? And that, with the amount of money you're dealing with here, that's a real risk. So being able to have the committee working within whatever parameters you establish for it, and then report to you, yes, we did it. Here's the balance and the holdings, is the healthiest approach.
Okay, I think we've discussed it.
I do have one other thing I would like some clarification on, and I will leave this up to the members of the committee. The Oversight Committee says the Executive Director of Financial Oversight. I'm told that that is our council CPA. That is the job description, just like the treasurer is always going to be. I'm wondering if we need to clarify tribal council, executive director of financial oversight. Just a question there.
I don't, I'm open to saying tribal council in front of that. I honestly, what I did was I looked up Jody Reese in Outlook, and that was his titles, and that's what I put in there. I don't believe that there is another one of those, because there's really only one executive director, but I'm definitely not opposed to that if we want to.
Okay, and that was my thought, because I've gone into Jody before and asked about things that were in the budget that I didn't understand, and find out that that's just the name, you know, that's the name in our accounting units. It's not what everybody says. So
If you want to make that specific, I think we're okay with that. Okay. Yeah, and you know, the amount is one thing, but we as council members had that fiduciary responsibility to oversee the funds. We hold the purse strings. I mean, that is our responsibility here. And the amount, again, is one thing, but policy and we have to follow the Constitution. So we will be held liable on how kind of decisions we make here. So then we have transparency with you. And as long as our financial guy gets information in a timely manner for us to make decisions, then we'll have transparency and we'll move forward. So, all right, enough said. Got a motion and a second. All in favor, signify by saying aye. All opposed? Okay. Item number 7, Councilor Taylor, you want to take that?
I do. That is an act amending Legislative Act 3517, Cherokee Nation Sovereign Wealth Fund, and declaring an emergency. I put that in the form of a motion.
You have a motion and a second. You also had a handout, a different handout that substitute for the one that is in your book. Council members, you're with that, correct? Okay. Discussion. Councilor Deere, you don't have anything to add? Okay. All right. Councilor Duncan, you good? Okay. All in favor, signify by saying aye. Aye. All opposed? Okay. Does that conclude our agenda here? Okay, is that it? I need a motion to adjourn. Got a motion and a second.